So the first slide deals with 3 doctrines. I go to the next slide, which deals with 6 more. One is severability, the good part from the bad part. If the good part and the bad part is so intertwined that the whole statute fails, then that's the sad fate of that law. Occupied field, which says that it applies to list 3. Recently, the Supreme Court has given a judgment on the question of, in the case of Jain Pharma versus Union, where they said that if the state governments have enacted debt relief laws, then under the Banking Regulation Act, you can't intrude upon that area. That becomes an occupied field as far as the state government is concerned. That's a completely interesting aspect which has to be studied more in detail. What about Article 246? Even if it is occupied by the state, cannot Parliament pass a law overriding that if it is Parliament is acting within its own competence? But occupied field, which is normally applied to list 3 subjects, has this time been applied in a conflict between list 1 and list 2. That's an interesting point, but we don't have time to discuss it further. Reading down. So idea is you save a statute, don't strike it down. Striking down should be a last resort. If possible, read down a particular section and save it by reducing the impact of a particular provision. Prospective overruling, we know that laid down in Golaknath. Unless a judgment says it's prospective, it will operate from the previous day. Now, there are 2 points here I would like to share with the audience. The Supreme Court in Golaknath says it applies only to the Supreme Court. Till today, after 50 years, I don't know why. Why can't the High Courts pass a judgment saying that we are striking down a state legislature or a union law and our judgment is prospective? What's the logic? Why can't the High Courts do so? I think they can. And other interesting case now pending before the Constitution bench in the Supreme Court is the case of the aftermath of Subramanian Swamy's case. As all of you know, in this case, the Supreme Court said that, there was under the Delhi Special Police Establishment Act, the CBI, the police could not inquire into officers above the rank of Joint Secretary without a sanction, without a permission from the central government, prior permission. So Justice Lodha has said, no, Article 14, corruption is corruption. It doesn't really matter whether you're an under secretary or an additional secretary or a chief secretary. All are same, strike it down. No problem with that law. Now, this case was filed in 2003 or 4. It was finally decided in 2015. What happens in those 12 years? Now, with the judgment delivered in 2015, what happens to cases which have taken place in between? There has been an acquittal, there has been a conviction, there has been a prosecution without sanction. In some cases, sanction has been refused. What happens to that? So there are judgments which now say that if a law is struck down later, it should not disturb concluded positions earlier. That's going to be an interesting question which will come up. Eclipse, we know that when you strike down a law, the law doesn't, it is only eclipsed. When that limitation is removed, the law acquires force, as the Supreme Court said, proprio vigore in Vikaji Naren Daktar's case. Now, that again, for the audience, I may say that raises a huge controversy of when is a law void, when is a law voidable. If it's ultra vires the Constitution, is it a voidable enactment? Is it a void enactment? Is it void ab initio? So many controversies come within that point also. So doctrine of eclipse within itself has got several facets. Of course, the last is proportionality, which all of us are familiar. Modern dental college, you apply the law as proportionately as possible. Try to have the least possible intrusion into rights. So these are the 9 doctrines. 2 general points are raised, and I'll go straight away to the examples. Can I have the next slide, please? The next slide, please.